and the defender, what is possible? What can we do? What is still legal? Well, we're going to try to answer those questions today. And talking about questions, your questions are very welcome. So please take the opportunity to write down questions and hand them in to our staff here at the right-hand side so that our two speakers can answer those after the two presentations. And I'm proud to introduce two very knowledgeable speakers to you today. As you see on my left-hand side, one from the US and one from Canada. And that's interesting because now we have a North American perspective on this important area of developing law. Two speakers, Colonel Kerry Corn on my left-hand side and Commander Andrew Thompson to my fair left. We'll do the same way of producing like we did yesterday, that is we do with two presentations, and afterwards we will answer the questions. I will introduce the two speakers one after the other, and we'll start with Colonel Kerry Corn. Judge Advocate with the United States Army. Currently, he has a very interesting assignment being Staff Judge Advocate at the U.S. Cyber Command. His long list, very broad experience, and many postings, but I mentioned the two most recent ones, which are interesting from a policy perspective also. That is the Chief of the Operational Law Branch, International and Operational Law Division at the Office of the Judge Advocate General of the Army. And before that, the posting of Deputy Legal Counsel of the Office of the Legal Counsel to the Chairman of the Joint Chiefs of Staff. Joint Chiefs of Staff. Broad military experience, also in terms of deployment. And I mentioned that we more or less together were in 2006 in Afghanistan for a relevant period, and he was their Chief International Law of the Combined Forces Command in Kabul. And in 1996, deployed with the United Nations. Certainly, I wish to mention his JD with honors in 1993, the George Washington University National Law Center, and in this South American context, Escola de Comando e Estado Mayor do Exército do Brasil in 2005. Well, certainly given his current assignment, he is the most excellent choice to address the issue at hand today, and I gladly give the floor to you.
Sure, thank you. Muy buenos días, señores y señoras, damas y caballeros. Permítanme, en primer lugar, agradecer a nuestros maravillosos anfitriones, el Fuero Militar Policial y a la asociación, ¿verdad?, por organizar este excelente evento aquí en la hermosa ciudad de Lima, por permitirme participar en la conferencia y tener la oportunidad de compartir hoy algunos pensamientos con ustedes sobre un tema muy importante, el de los desafíos emergentes en el ámbito del derecho internacional, presentados por el nuevo dominio a lo cual nos referimos en términos generales como el ciberespacio. Pensamientos que tengo que destacar desde el comienzo representan mis opiniones personales y no las del Comando Cibernético de los Estados Unidos, ni del Departamento de Defensa, ni del Gobierno de los Estados Unidos específicamente. Como se puede ver, he logrado a lo largo de los años un cierto grado de competencia con el idioma bonito de español, y pensé en dar mi presentación completa en español. Sin embargo, debido a la naturaleza un tanto esotérica del tema y reconociendo que la descripción es la mejor parte del valor, pensé que sería mejor no transgredir el derecho humano de todos ustedes contra el castigo cruel e inusual, especialmente en el caso de los traductores, así que voy a seguir desde este punto en mi lengua materna. Okay. So, I had the great pleasure and fortune to travel throughout Central and South America over the years for work, for family reasons. But I've not yet had the chance. This is my first time here in Peru, and I'm very excited to be here. And Sunday, my son is here. He's been in and out a few times, and I'm going to take him to see Cusco and Machu Picchu. We're both extremely excited to see these beautiful places. Obviously, the world has changed significantly since the days of the great Incan civilization. And some would argue that never before in history have we seen a rate of change as accelerated as we have in just the last 50 years. Advances in technology have been both incredibly empowering and astounding. And some would argue that developments in the field of information technology, and especially the development and explosion of the internet since its conceptualization in the 1960s and real birth just in the 1990s, are at the heart of this unprecedented pace of change. I could ask how many of you have cell phones in the room, but we would see everyone's hand go up, right? We know that we are at a point where almost everything is interconnected in our lives through this Internet of Things, the Internet connecting in all sorts of devices and dominating in many respects on our lives today, private sector and across to the government. As I said, on the whole, the advances in information technology and the developments of the Internet have been formidable tools of empowerment, generating innovation, development, and the diffusion, accessibility, and advancement of knowledge. Today, roughly 15 billion devices are interconnected. 15 billion devices around the world are interconnected. And estimates project this number to reach upwards of 200 billion by 2020. At the same time, the world's growing dependence on cyberspace. Whether you prefer the U.S. Department of Defense's very simple definition of cyberspace, or if you would prefer a much more complicated dictionary definition of cyberspace. Okay. This has created tremendous vulnerabilities and security threats. As noted in the Department of Defense's, U.S. Department of Defense's 2015 cyber strategy, today our reliance on the confidentiality, availability, and integrity of data stands in stark contrast to the inadequacy of our cyber and data of cyberspace for a wide range of critical services. This reliance leaves us vulnerable in the face of a real, dangerous, and growing cyber threat. States and non-state actors have identified cyberspace as both a domain through which, as well as a means and a method by which to pursue political objectives. Through, among other things, espionage, the theft of intellectual property to undercut technological and military advantage, and worse, the conduct of disruptive and destructive cyber attacks on critical infrastructure, systems, and resources. This is a threat to civil society. It's certainly a national security threat for all countries because certainly in the United States, and I would suspect all the countries represented, our military communications networks, much of what we do with our military systems are interconnected and layered on the backbone of this broad private system called the Internet. The emergence of malicious and offensive cyber actions as tools of statecraft, to include warfare, have squarely implicated the core question of whether international law is applicable to cyberspace, and if so, whether it is adequate to the task of regulating cyber conduct. Some argue that it is not, that we need to develop an entirely new normative system, new normative regime to deal with cyberspace. Others take the opposite view, stating that international law clearly applies to cyberspace. This latter view is the position of the United States, as reflected, among other places, in the White House's 2011 International Strategy for Cyberspace, various public statements, and its submission to the United Nations group of governmental experts on developments in the field of information technology in the context of international security. It is also the position adopted by the group of experts who produced the Talon Manual on the international law applicable to cyber warfare, and more recently by the UN group of governmental experts itself in a 2013 report, and more recently reaffirmed in the 2015 report. Well, I count myself in that latter group. I believe international law absolutely applies to cyberspace. I also recognize that, as they say, the devil is often in the details, and determining whether international law applies is much easier than determining how it applies to any given situation. How it applies to specific actions in cyberspace within different and sometimes novel contexts. This is the challenge I now face on a routine basis in providing advice to military commanders and policymakers in the area of cyber. Harold Koh, currently Dean of Yale Law School and formerly the legal advisor to the U.S. Department of State, often speaks of the processing existing international law rules to new technologies and situations, looking to first principles and doing the difficult legal work of applying those principles and rules to new and challenging facts. This process is not new. We've seen it develop before. Where we are in less than 150 years in flight, in air operations, we are miles and miles from where we began with the Wright brothers or 14 Beach. I'll give a shout out to my Brazilian cohorts here. This process, as I said, is not new, and within each era of technology or situational change, the international legal community has faced the same challenge of applying and adapting existing rules to evolving circumstances. This was the process which, in large measure, the international group of experts undertook in the Talon Manual, focusing primarily on the applicability of the in-bello rules of the law of armed conflict to the so-called wild cyber warfare, and my colleague will speak more to the specifics of the in-bello aspects. I'm happy to take questions as well, but I'm going to focus on a different area. At times, this process of translation is relatively simple. For example, the legality of new kinetic, high-explosive weapons can usually be addressed through standard application of the Law Act rules governing the means and methods of warfare. Sometimes, newer evolving technologies or situations bring relatively dormant rules to the forefront, requiring a deeper understanding or a renewed look at their meaning. Consider, for example, how the predominance of armed conflict against non-state actors since the attacks of September 11th and the nature of those conflicts has elevated to central importance and generated substantial debates about the notion of civilians directly participating in hostilities, right, and law or detention principles. These were notions, these were rules we were all familiar with. Article 51 of AP1, Article 13 of AP2. But until we really started getting into operations that put these at issue, that took a renewed understanding and a deeper look at these. At times, however, new technologies enable states, and at times non-state actors, to operate in unprecedented ways that put particular stress on the contours of existing international law regimes, create legal and policy ambiguity, and as such create unnecessary risk. Risk of both inaction and overreaction. It is my opinion that this is exactly what we are seeing play out today in the realm of cyber. Like the focus of the Talon Manual, much of the discussion of the applicability of international law to cyber has focused on the use in bello, unique body of international law governing the interaction of states with individuals in the circumstance of armed conflict. This work has been incredibly important, and I'm happy again to take questions on the topic, but I will focus the remainder of my remarks on the area where I believe greater ambiguity remains: the international law regimes governing the relations of states interstate relations. And more specifically, although I will touch on the use ad bellum aspects of cyber, the malicious cyber actions we are seeing, both by states and non-state actors, falls in a zone below this threshold, in what I call cyber confrontation. I chose that word carefully. It doesn't necessarily fully accurately represent, but I don't use the term cyber conflict because of the connotation of armed conflict, which is the question that usually is generated when we talk about cyber and that development. But at first, a few words about the nature of cyberspace itself and going into it. With little exception, really every system important to our day-to-day lives, both at the is a near ubiquitous means to access and create effects on almost every computing device or system on the planet, whether governmental or private. Another complicating factor, both from the perspective of security architecture and discerning and correctly applying legal regimes, is the layered nature of cyberspace. The interconnected nature of cyberspace, combined with the basic technical protocols underlying its functionality, and the woefully inadequate security architecture built into the system, has created a truly unique environment that provides threat actors multiple different means to compromise networks, hold critical data and systems at risk, and inflict harm, whether physical or virtual. The environment is clearly one of asymmetric advantage to the attacker, providing relatively low cost, clandestine means to engage in malicious actions across national boundaries from halfway around the globe. What we are seeing, and what are some examples that most of us are already familiar with, in addition to pervasive national and transnational criminal exploitation, we have seen a steady increase in not only the sophistication of cyber tools and the capability of threat actors. We have seen a steady rise over the last several years of state and non-state actor-sponsored malicious actions. The advent of cyber has certainly marked a sea change in the sphere of espionage, enabling sensitive data exploitation and exfiltration on an unprecedented scope and scale. The hacking of the United States Office of Personnel Management and the exfiltration of sensitive information of 22 million individuals being a prime example. 22 million individuals. Cyberspace has also enabled the theft of intellectual property on a massive scale, and estimates of the economic impacts are in the range of $300 billion a year in the US alone. We have also seen a rise in disruptive cyber actions, such as Iranian distributed denial of service attacks against the US financial sector, similar attacks by North Korea against internet service providers in South Korea, as well as massive denial of service attacks conducted against GreatFire.org and GitHub, which many in the press attribute to China's Great Cannon, part of its Great Firewall structure that it maintains. And we have also clearly entered into an era of destruction caused through cyber. Most recently, Russia has employed cyber against the Ukrainian power grid, as reported in the press. And we have seen attacks like the Shamoon virus, which damaged upwards of 30,000 computers of the Saudi-owned, state-owned oil company, Aramco. And of course, the attack against Sony Pictures last year, which involved the deletion of millions of dollars worth of data, damage to systems, and threats to employees and others, all in the unprecedented attempt by North Korea to coerce Sony from releasing, and by extension, to coerce people, to prevent people from seeing what North Korea assessed to be an offensive movie. I did not see the movie. I heard it was really bad, and that's okay. But if you think about really what took place, a leader from one country was able to reach all the way across the globe, across borders, in an unprecedented way, to directly try to influence and coerce, essentially, I would say, civil and political rights in another country. The freedom to make that movie, the freedom to publish that movie, and the freedom to view that movie. So these are a few examples. There are many others of the growing cyber threat. The transformation of cyberspace into a traditional arena of interstate maneuvering, and I would say, to agree, confrontation. The question is, what, if anything, does international law have to say about these different events? So there are a number of particularly challenging issues in international law. I'm not going to necessarily offer what I would view as the answer to these questions as much as identifying what I think are some of the challenging issues. And starting with the fact that there's a lack of sort of common terminology or lexicon, even the notion of cyberspace that I brought up earlier. You can ask 50 different people in the field and you'll get 50 different definitions of what cyberspace is. Some object to the use of cyber as a term in itself on the ground that it connotes a militarization of cyber, of the domain. There's also a difficulty in drawing the distinction between that which is the realm of policy and that which is the realm of law. And at this sort of strategic level, the overlap and the blurring of those lines. And when states do make assertions about positions on things, are they making those assertions based on a matter of policy, or is that their view, their opinio juris of what the law is? So if you look, as I said, over on the right, and I'll come back to this in a second, I view these traditionally having been three separate spheres in international law at the interstate level. The use ad valorem, which most of us are familiar with, and I'll touch on it quickly. This intermediate area, which has really gotten fairly limited attention over the years, in the area of state responsibility and this principle of non-intervention. And then over on the left, what I call the Lotus Zone, referring to the 1927 foundational case by the Permanent Court of International Justice, which in the most narrow sense involved the question of Turkey asserting jurisdiction over French nationals based on a based on the notion that states are sovereign equals and that international law is something, a very positivist view, that international law is only created by states, right? That restrictions on the independence of states cannot be presumed. That is, international law under this reading of Lotus is a permissive environment. Unless states agree to prohibitions and restrictions, states can act freely subject to diplomatic challenges and issues. Others argue that Lotus's meaning was somewhat more narrow and that the validity of Lotus can be questioned, but I think most international law folks certainly recognize this as a potential position. Okay? So now a word on peacetime norms in cyberspace. The 2015 Group of Government Experts report again reaffirmed that international law applies to cyber, but they admittedly, they failed to define the question of how. And they developed a series of voluntary, non-binding norms of responsible state behavior, a very important step forward. And there's continued work to develop this area. Norms such as not interfering with computer emergency response teams that states are developing to respond to problems in critical networks, not taking malicious actions of certain natures. What's important, though, I think, is that recognition seems to imply that actions addressed by norms are actions that aren't otherwise prohibited by international law. Because if they were clearly prohibited, the work would be up. So, the use of that, we know the structure of the UN Charter, Article 2.4, the threat of use or use of force against the territorial integrity or political independence of any state, or in any other manner inconsistent with the purposes of the United Nations, unless otherwise approved by the Security Council under Chapter 7, or an exercise of the inherent right of self-defense, which reflected in Article 51. And we know there's some debate as to whether there is a space between the provisions. The U.S. view is that a use of force is coextensive with an armed attack under Article 51, and a use of force gives rise to the right of self-defense. Other countries take different positions on that matter. The Department of Defense Evolved War Manual, which was recently published, looks at the question in cyber. If cyber operations cause effects that, if caused by traditional physical means, would be regarded as a use of force under the use ad bellum, then such cyber operations would likely also be regarded as a use of force. Whether direct physical injury and property damage resulting from the cyber event looks like which we would consider as a use of force if produced by kinetic weapons, cyber activities that approximately result in death, injury, or significant destruction would likely be viewed as a use of force and might trigger a state's inherent right of self-defense, which would not be limited to a cyber response. And we understand that under the framework of international law. This is the same approach the Tallinn Manual takes, to the limited extent that addresses the ad bellum question, and applies the scale and effects analogy, the International Court of Justice's decision, the Nicaragua decision, foundational case in international law. So it's essentially a totality of circumstances principle of whether a cyber action has crossed that threshold in international law into what we would say a state of hostilities or armed conflict. But as I said earlier, I don't think that that's where we're seeing most of the activity in cyberspace. Where these actions, that some of which I've identified, the OPM breach, a breach into the Joint Staff Networks last year by an adversary, the Saudi Aramco case. So where do these fall on this spectrum? So let me talk about the question of sovereignty itself in international law, and how I believe sovereignty is being stressed as a principle because of cyber. We certainly know this question most frequently comes up in the area of espionage and the conduct of espionage by states, and whether espionage is or is not a violation of international law. This is a tough question. There's most I think recognize there's a minority that would argue that international law prohibits espionage. I would suggest that the actions of states writ large, not just the United States, but across the board, tends to belie that or underline that position. States have open legislation that authorizes, enables state organs to conduct espionage, which would be very inconsistent with the notion that those activities were prohibited by law. But the means by which you conduct espionage, those are harder questions and could implicate other principles in international law that you might violate in how you conduct espionage. And there's no question, as I mentioned, that the scope and scale of espionage today is raising new questions about these principles. But at the heart of the question is this notion of sovereignty. There are some who take the view, and it's a reasonable view, that sovereignty itself is a bedrock rule of international law. That The entrance into the territory of another state without that state's consent is in and of itself a violation of international law. I think there are difficulties with that position. I will give you my personal view that I believe sovereignty is a foundational bedrock principle of international law, but not a rule in and of itself. It is a bedrock upon which states have come together and agreed to more specific rules, such as the rules in the UN Charter prohibiting the use of force. This, since the Treaty of Westphalia and the birth of the modern nation-state system, states have engaged in activities that would implicate this issue, and so we either have to accept or consider that states conducting espionage, for example, which often involves the entrance into the territory of another state without consent, as an exception to this general trespass rule of sovereignty and international law, or that it's not a prohibited action unless it involves something that triggers a separate ruling. These are tough questions. And in the nature of cyber, they're called into question with much greater force. The notion of national, physical, geographic boundaries fall to the wayside in cyber. When you think about a distributed denial of service attack, the technique involves the actor who's going to conduct the attack gaining access to computers around the world in different countries without authorization, without knowledge, converting those computers into a robot network, a botnet, and through commands, having all of those computers simultaneously start to send traffic to targeted systems for computers, and overloading those systems to the point where they're not functioning. That's the standard technique that's used. So these are entrances into the territory of other states. Cyber crosses international boundaries every day. Every email you send, you can't say, I want it to go only for this route. It routes automatically and can go through any number of countries to arrive at its destination. So this notion of sovereignty is sort of central to the cyber domain and a very challenging question that I think international law will be pressured to resolve over the next years. Now, the law of state responsibility, focusing really on this principle of non-intervention, because as I say, I see the majority of these actions happening below this use of force threshold. In this confrontation area, it has brought to the forefront what I would say is a relatively dormant principle, the principle of non-intervention. The principle, again, recognized in the Nicaragua decision, but it's fairly defined in international law, but challenged nonetheless this new space. It's a principle of customary international law reflected in Article 2.1 of the Charter. 1970 UN Declaration, as well as other sources. It's generally considered to prohibit forcible, dictatorial, or otherwise coercive action, which is defined as action that forces a state against its will to take a particular course, or prevents it from taking a particular course of action. It involves a serious level of interference in relation to an important sovereign right. It must bear on matters in which each state is permitted by the principle of state sovereignty to decide freely, such as the choice of political, economic, social, and cultural system and formulation of foreign policy. For example, in the Nicaragua case, the United States, according to the International Court of Justice, was found to have violated this principle by funding the Contras, which was deemed to be an interference, an unlawful interference in the sovereignty of Nicaragua. When you have an unlawful interference considered an unlawful act under the law of state responsibility, it triggers the right of the aggrieved, the offended state, to take some action in response. but not an action that would rise to the level of a use of force. There's this body of law called countermeasures, which itself has a number of elements which are, again, challenged and stressed in this domain. The countermeasure must be necessary and proportionate, taken against the responsible state, cannot breach the prohibition against the use of force, as I mentioned, must be suspended as soon as the responsible state complies with its international law obligations. Arguably, unlike self-defense, cannot be taken in an anticipatory fashion. It's limited more than the international law and the customary law on the right of self-defense. It generally requires prior demand to the offending state to cease the internationally wrongful act that state is conducting. That violation of international law, likely the intervention, you have to give notice. Giving notice is very challenging in an area like cyber response, where your ability to respond may be in nanoseconds to take a countermeasure to defeat what's happening to you. So this stresses some of the elements involved. And it also, as I noted before with the example of a botnet in various countries, if what you're trying to do is disable the software, the code that has been unlawfully implanted in all of these computers, typically countermeasures are addressed against the state that's taking action against you. What are the implications for the third-party states in whose infrastructure within their territory the attacks are coming from? Not because they're shooting at you, because someone else has co-opted their infrastructure. These are all very challenging areas, as well as the principle of necessity in international law to respond. I just started reading a book, Adam Siegel from the Council of Foreign Relations, called The Hacked World Order. He describes 2012 and 2013 as year zero in the battle over cyberspace, as the year the nation states visibly reasserted their control over the flow of data and information in search of power, wealth, influence, the standards for interstate jockeying that we used to. He compared it to the beginning of the Cold War in 1947. Maybe he's overstating the proposition somewhat, but it's probably unlikely that cyber operations will ever produce the type of destruction that kinetic weapons can produce. The threats that cyber attacks present are, as I said, real, pervasive, and very much potentially destabilizing because, as I say, of the pressure that's put on these different regimes, sort of crushing what had traditionally been separate areas into one space. In the face of this emerging threat, international law must play a critical role in promoting stability, in conflict prevention, and the cooperation of states in developing this international law, in developing sort of these peacetime norms and the rules of the road of how we're going to interact, so we don't have miscalculation unnecessarily. Thanks.
Thank you very much, for this fascinating presentation. And we will recall that we started out the question, does the normative body of international law apply to this complex field? And as he said, yes, many say it does, but then it's another question, how? And then we come into some charges, waters to use that term. We'll go into this probably also more with your questions, which are very welcome. I move to introduce Commander Andrew Thompson from Canada, currently the Director of International and Operational Law at the Office of the Judge Advocate General in Ottawa. Broad international experience, also deployments, and I see here Afghanistan in 2009, 2010, and law, but also in the field of military justice and civilian labor. He was the deputy judge advocate at the First Canadian Air Division. Of course, also broadly, school that I mentioned here is honors BDA, Wilfrid Laurier, University of Waterloo, Canada, and the LLM at the Columbia University in New York City. From his current position, he is he's an expert in the field that we want to address this morning. I'm very pleased to give the floor to you, please.
Thank you. Eu quero dizer também que eu estou muito feliz de estar aqui. Eu quero dizer graças ao Fuero Militar Policial da Sociedade. This is a golden opportunity to be here and to be part of this discussion. I think that for those of us who provide advice for governments and for militaries, part of that is discussing some of the challenges that arise from new technologies, which is the subject of this panel. And so, while this is a legal panel, the subjects are perhaps as well known and even more attention-grabbing in the wider public sphere. So today I'd like to try to separate some of the surrounding non-legal discussion, if you will, from the relevant legal questions. So I'll briefly discuss some of these questions relating to the existing legal framework around new technology and means of warfare. And then we'll see how it applies in the case of drones, a little bit of terminology. A drone can also be referred to as an unmanned aerial vehicle, UAV, and the cyber. And then in the last part of my presentation, I'll briefly focus on the hostilities framework. I won't address the full spectrum of operations, particularly those outside of an armed conflict, as my colleague has so ably done in this very thoughtful presentation. I'm simply going to consider these in the context of an armed conflict where international humanitarian law or the law of armed conflict applies. Notwithstanding significant debate on the challenge of the use of drones and the conduct of cyber operations, international law applies, as you've heard from my colleagues at the table here. It's capable of applying in the normative sense, I think is the other main point I'd like to get across. IHL is sufficiently broad to cover any new developments and technologies, including remotely controlled, automated, and cyber weapons systems. I think that the uses of drones and cyber have been proxies for ongoing debates within international humanitarian law and international law. And these debates are ongoing and would exist irrespective of any method of warfare. And I think that sometimes some of the controversy that arises in the use, particularly with drones, really reflect controversies that are live in the law and are not dependent on the particular weapon system being used. Simply, if there's an armed conflict, international humanitarian law applies. And I think that it will continue to provide the framework that we need to regulate the conduct of hostilities. So does cyber cross into a new legal frontier without applicable law? Well, let's pause for a second. And I'm going to say no. The circumstances surrounding the use of cyber that governs how they can be lawfully used, it exists. It's not the mechanism itself. And if it's in an armed conflict, and again, I'll emphasize this point, it's got to be compliant with international humanitarian law. And if it's outside of an armed conflict, then it's more of a law enforcement paradigm, more of a human rights law paradigm that applies. And I think that in a lot of the debate on drones and cyber, these points tend to be obscured. So there was a Russian governmental publication that came out a few years ago called the Conceptual Views Regarding the Activities of the Armed Forces of the Russian Federation in Information Space. And there's a passage that I'd like to cite. And it said that the main objective for the development and cooperation on the global level is the establishment of the international legal structure governing, inter alia, the military activity of the states in the global information space based on the principles and regulations of international. The publication notes that the Russian armed forces are indeed guided by principles of international law and international humanitarian law, yet the objective suggests that the current international law, the lex lata, is not sufficient to cover cyber activities. And there are still some who share those views, commentators in some states. However, since that time this was mentioned on current point, we've had the Tallinn Manual of International Law applicable to cyber warfare, as well as the United Nations Government Group of Experts. And I think that they've been received with a relatively wide approval. And the UN report recommended recourse to ex-ante international law. As they said, in particular, the Charter of the United Nations is applicable and is essential in maintaining peace and stability and promoting an open, secure, peaceful cyber environment. And then the Tallinn Manual, the authors, the group of experts, I think more pointedly rejected any assertions international law is silent on cyberspace in the sense that it's a new domain subject to international legal regulation only on the basis of new treaty law. On the contrary, the experts unanimously concluded that the general principles of international law apply to cyberspace. I mean, these documents are important because given the sensitivity, and again, this was alluded to by my colleague, given the sensitivity of all things cyber, it's difficult to discern and to measure what is the safe practice. And so consequently, from an international law doctrine sources perspective, we're generally left with limited expressions of the views of states that we try to pick through various speeches of doctrine. But there's methodological weaknesses and challenges with this because the doctrine and the other speeches are not necessarily there to convey a sense of opinion yours against our reform indicated. There's other views that are infused in that, political, perhaps public affairs. So while the unique features of cyberspace are complex, from the infrastructure to character to information, I think that there is a consensus now that the application of international law in these circumstances, although still work in progress, nonetheless applies. I'm now going to move on to a discussion about the arguments and the discussions that are going on, I think, in the public sphere with respect to drones. And they're often a proxy of sorts for the contentious issue in current international humanitarian law. So principally, the relationship between international humanitarian law and international human rights law, and back to sources of international law, particularly how do we define customary international law now? And then a related issue is what's the role of soft law and various non-governmental organization initiatives. So to talk about this, I'd like to consider a blog by Human Rights Watch, which is a United States NGO. And they were covering the Human Rights Council, the UN Human Rights Council, when it was considering a resolution for the use of drones in 2014 that it subsequently passed. Now, Human Rights Watch, in response to the concerns that the Human Rights Council was reviewing with respect to drones, there was some criticism going back. Was the Human Rights Council the proper venue to talk about international humanitarian law? So there was that, and the Human Rights Council itself came back and said, well, this is part of our mandate because of the mutuality of international humanitarian law and international human rights law. So let's unpack that a little bit. First of all, I think that the role of the merits of the Human Rights Council in assessing international humanitarian law is debatable. It was stood up not really to consider IHL violations. That was a role that it subsequently assumed. And that I think that it's taken on a large role in how they view the use of drones, particularly in armed conflicts. And so this gets us into the meat of the discussion of what exactly is the relationship between international humanitarian law and international human rights law. We have some pronouncements, most notably by the International Court of Justice, in the Nuclear Weapons Advisory, in the Wall Advisory, and the Armed Activities in Congo. But beyond that, there still must be a specific rule of law in particular that applies. So is it the International Covenant for Civil and Political Rights, Article 6, arbitrary deprivation of life? Well, the Canadian position expressed in a number of submissions to various UN processes and bodies is that it doesn't, the ICCPR does not necessarily extend extraterritorially. I believe that's also the view that's contained in the recently released United States Department of Defense Law War Manual, which is to say there's a real debate as to whether or not, as a matter of treaty, it applies extraterritorially. So then, if we were to say that it applies in an armed conflict, does it apply as a matter of customary law? Okay, then where is the state practice in Kingdom Europe demonstrating that the provision applies extraterritorially? The Hassan judgment of the European Court recently canvassed the issue, and they noted that of 3 derogations out of 18 by state parties to the covenant that applied in international armed conflict, it seemed that there's only, as I say, 3 out of 18, and the better interpretation was they were by states that armed conflicts on their own territory. So I think there's a real question as to saying what, in the case of drones, if we're talking about the deprivation of life, what is the international human rights rule that's applicable? What are we actually talking about? At the very least, it's an issue that is worthy of debate, and I think in some of the reports we don't see that debate there. And then I would also consider another report called Death by Drone by the Open Society. And they rely in assessing the validity of drone strikes on the International Committee of the Red Cross's interpretive guidance of their participation in hostilities, and they essentially adopted it as a law. Now, it's very, very thoughtful work, and there's a lot of time going into it. However, a number of commentators, particularly those who have advised militaries from states, have criticized some of its contents. In particular, the issue of continuous combat function. It may inappropriately narrow who is a member of an organized armed group, and the notion of the revolving door between directly participating in hostilities and civilian status may incentivize more mixture with the civilian population rather than less. So the question of the parameters of direct participation in hostilities and membership of organized armed groups are key in determining whether or not an individual is subject to a lawful attack. Thus, the absence of the critical evaluation and discussion of the ICR guidance in this particular report really goes to the centrality of the assertions contained therein. So the drones have been a magnet to sort of the larger debates in international law concerning the use of force and the relationship between IHL and IHRL. The question of the development of international law and also accountability is not solely technical debates. You see, because the underlying questions are more than just about legal methodology. Their tension in normative approaches, but towards a shared objective, which is to mitigate the effects of armed conflict. The methods and means, whether or not a drone or a cyber weapon is used in an armed conflict, they're limited by the provisions by IHL, the choice of weapons, and in the way that they're employed. They can't use means and methods of warfare of a nature to cause superfluous injury or unnecessary suffering, or they're incapable of distinguishing between civilians and civilian objects and military objects. So just briefly, some of the particular LOAT considerations or IHL considerations with respect to the use of cyber weapons. Cyber warfare refers to the means and methods that rely on information technology and are used in the context of armed conflicts. There's other definitions of term but they all are subject to IHL, and again, it's been indicated how it applies can be a little tricky. For example, it's not clear when you reach the threshold of an armed attack. And different states have different views about what constitutes an armed attack, and that has been important and is relevant in also determining these Vellum requirements dealing with cyber or a putative cyber attack. But there seems to be little disagreement that the cyber attack could become an armed attack under certain circumstances, giving right to the exercise of right of self-defense. As the International Court of Justice said in the Nuclear Weapons Advisory Opinion, UN Charter provisions apply to force regardless of the weapons employed. Another area that requires further clarification is whether or not cyber attacks can be characterized as violence, as referred to in Article 49 of the additional protocols to the Geneva Conventions, AB1 that is, which defines attacks as acts of violence against the adversary, whether in offense or in defense. But not all cyber operations would necessarily cross the threshold in violence. But again, this was indicated a cyber attack that would certainly be conceived as being analogous to a traditional kinetic attack. I'll now move to some of the low-actor IHL considerations for the use of drones or unmanned aerial vehicles. So I think we can broadly fit them into three categories. SUV or drones, remotely controlled systems, which have human in the loop. Systems that are remotely controlled by an operator through some form of direct radio signal, and they can be, the operator can be close in the same operational theater or very far away in another country. And UAVs are certainly a common feature of contemporary armed conflicts. We also have automated systems, which are called human, or referred to sometimes as human on the loop. They're meant to perform activities executed within more pre-programmed parameters and do not require the command from a human. However, the human operator can alter or cancel the mission. Again, we've seen uses of these in contemporary armed conflicts. And then the other one, which is perhaps the most talked about, which we're most interested in, are autonomous systems where there's not a human in the loop. And they use essentially programs akin to artificial intelligence to operate independently of human commands. And they could run the gamut, in theory, from locating, identifying, and destroying a target without any human action. These systems, not in use yet, that I'm aware of, and they raise serious ethical questions, certainly. But again, there have been certain organizations in the past that said they were illegal per se, and I think that it's hard to say that the technology is illegal per se, at least under the current tenets of international law. There's ad hoc treaties, and then there's the requirement against using a weapon or means or method of warfare that causes superfluous injury. Well, artificial intelligence, or at least in the conceptual stages, we're not there yet to have something that's concrete enough to make those inquiries. But I think at the minimum, any new developed systems would obviously have to have checks and balances and ensure that they respect IHL. But they do bring a lot to the table. Real-time aerial surveillance capabilities, assist belligerents in carrying out attacks more precisely against objectives. And this in turn can reduce collateral damage. And like any new system, they'll have to comply with IHL. And I think I'm persuaded that they will. And like other weapon systems, they'll have to abide by the principles of international humanitarian law, and that includes targeting. So only military objectives, the principles of distinction, necessity, proportionality must also be respected. And because they have this greater fidelity, they may also help with respect to the principle of precautions. There are issues that are raised. Not all drones are necessarily piloted or operated by military members, and so it does raise the question: is that they're likely directly participating in hostilities if you have civilians? And that's one of the things that I think that we still need to grapple with, but it falls in the category of how you apply the international humanitarian law. So, in conclusion, new technologies raise old questions. And the questions are, can the law cope, or do we need new law? They're proper questions. But I think that part of it's because as means and methods change, the uncertainty of the new, including the fear of beyond potentially awesome potential, and wrest attention away from the proper way to approach these questions. International law and IHL specifically have great reserves of flexibility because they've developed alongside all human endeavor, including our waging of armed conflict. The exponential growth of new means of warfare, raises the question that any attempts to regulate it through a series of ad hoc treaties or laws, could quickly be overtaken by events, and it's susceptible of having ultimately a legal environment that's governed by, a less principled patchwork of individual weapon prescriptions. So I think that IHL has provided and will continue to provide an appropriate framework to regulate conduct of facilities, including cyber warfare and the use of drones in armed conflict. Thank you.
Thank you very much for this very broad expose, touching upon several areas of the law, also venturing into the discussion about the applicability of international human rights law. So it's helpful to also sketch the complexity of the total field. We may come back to that in questions. I saw one question passing by. Maybe there are more, and please feel free to phrase them in Spanish because we have the Spanish-speaking speaker here at the table. And we also may use the microphone if you find that more appropriate. Please.
Bien, déjenme enfatizar primero que realmente tenemos preguntas. Mejor una pobreza de que sentar ahí mirando a mi cara fea. Dos preguntas aquí, las dos parece que son dirigidas a mí, pero yo creo que la segunda es simplemente para los dos. La primera pregunta, ¿existen armas con autonomía suficiente para extinguir la línea de responsabilidad o solo es ciencia ficción? Participé hace 2 semanas en una conferencia sobre esta cuestión de armas autónomas. Déjame empezar que la posición, la política actual del Departamento de Defensa es que una pequeña excepción, hay que haber un humano, se dice, en el proceso de decisión en cualquier momento de uso de fuerza, cualquier arma. Entonces, prohíben básicamente armas autónomas. Y hay varias razones, hay debates de por qué, si es mejor, no mejor. Yo personalmente, en el fondo, yo creo que tiene mucho, si no todo que ver con la cuestión de responsabilidad. Y responsabilidad de comando, de mando. Un armamento autónomo, ¿quién va a ser responsable por un error? El sistema. Vamos a hacer un juicio con un computador, alguna cosa aquí. Eso es incoherente, en mi opinión, con los principios y las necesidades de la ley. Hay ciertos sistemas, principalmente en la parte naval, sistemas que son hasta cierta forma autónomos, pero en la defensa, que pueden reaccionar con la rapidez necesaria, pero es un ambiente bien específico. Muy difícil imaginar, muy posible, pero muy difícil imaginar en alto mar un avión que está en una actitud de ataque que un sistema va a confundir con un carro civil. pero eso es una excepción muy limitada. Yo creo que si es ciencia ficción, no, lo que he aprendido en los últimos años trabajando en mi posición actual yo soy una persona de informática, de nada, me enfoco en la ley. Esas cosas son demasiado difíciles para mí, pero viendo la capacidad de invención, no, yo creo que en el futuro sí sería posible hacer ciertas cosas autónomas. Y en el área de ciberespacio, se puede imaginar, si, volviendo al ejemplo del botnet que expliqué, es una cuestión de segundos, milisegundos a veces, cuando comienza un ataque. Y si hay una forma de reconocer eso, ¿por qué? Porque solo viene de un programa malo que alguien ha instalado. Se puede reconocer y desarmar eso sin causar daños colaterales, efectos colaterales. Hay una cierta senso bueno de tener esa capacidad, ¿no? Y la segunda pregunta, ¿puede mencionar algún caso en el que se haya sancionado a algún operador militar por daños causados a civiles mediante drones? Yo voy a responder y pasar la pregunta a mi colega aquí. Un caso específico no tengo en mente ahora, pero lo vería yo igual que cualquier uso de fuerza. Como él ha mencionado, si alguien emplea fuerza lanzando una bomba o un misil por un dron, sin verificar el objetivo como un objetivo militar, sin suficientemente hacer todas las precauciones requeridas por el DIH, puede haber responsabilidad por un error, como bien dicho, no cumplir con la. Pero la diferencia entre un dron y un avión pilotado es nada más que el piloto está lejos en el terreno, pero está manejando un sistema igual. En mi opinión.
I think I've got the gist. I think with respect to the first question, the point I would know, is this science fiction? Maybe now, but I was reading an article by Peter Singer the other day, and he's written a lot about robotics and autonomous weapons, and he referred to a survey of a number of artificial intelligence experts, and then I may have the question not exactly correct, but it was, do you see that there could be circumstances where artificial intelligence could arise? It would be difficult for humans to control it, to get that smart. And the response was something like 50% of those surveys said by 2040, and 90% said that they figured we'd be there by 2070. So, I mean, these are real issues, and I mean, I think that the ethical debates, speaking personally, are really properly those that we need to have in full, because I mean, my sense is it's coming. It's not going to come today or tomorrow or necessarily the next couple of years, but I think it's we're moving in that direction by leaps and bounds. I think just with respect to the second question, I just follow on to Colonel Corn. It doesn't matter what the weapon systems are. It matters what the circumstances are, what the law is. If it's an armed conflict and it applies. It doesn't matter what the attack is or what's used with the attack. The most rudimentary means or the most advanced means. It's the same rules that apply.
Voy a hacer preguntas aquí. La primera aquí. A invasão de um computador de um Estado para outro Estado pode ser considerado um ato de guerra. Entendeu? Yo creo que el simple invasión de un computador difícilmente sería considerado un acto de guerra. Pero como dice en la presentación, yo creo que eso es igual en la esfera física. Lo que se considera un acto de guerra, un uso de fuerza ilegal, según la Carta de la ONU, es una cuestión de los hechos. Va a depender, la famosa depende de los abogados, ¿no? ¿Qué sistema es? Un sistema de una compañía del país no es lo mismo que un sistema crítico de las Fuerzas Armadas, por ejemplo. Un sistema que puede causar daños y visto en relación con otros hechos como un acto de preparación para una invasión más grande. Depende de los hechos siempre, pero el simple acto de entrar, vamos a decir, en un computador, eso está pasando de por día. El uso reciente, según el gobierno ucraniano, los rusos hicieron un ataque cibernético contra la infraestructura eléctrica. Cortaron la luz dentro del problema que ellos están involucrados. La presencia del malware, del programa malo, eso depende del estado, de la situación que está, cómo va a interpretar eso. Pero tenemos que tener mucho cuidado interpretando un acto cibernético, digo yo, inmediatamente como cruzando la línea. Muchas veces cuando oigo esa pregunta, se piensa simétricamente, pues es un acto de guerra cibernética. La respuesta va a ser cibernética. Vamos a tener una guerra cibernética controlado y mantenido dentro. Eso no es. Si es un acto de guerra, es un acto de guerra. Que da el derecho del Estado atacado a enviar cualquier medio de fuerza proporcional según los principios de necesidad y proporcionalidad. Se puede abrir una caja que no se debe quedar. Hay que tener mucho cuidado en ese mensaje.
Muito bom pergunta. I think that gets to the heart of, of how you apply it to cyber. If we invade another state's computer, what's being invaded? I mean, it's part of a network that can be distributed beyond just the territorial boundaries. There's infrastructure, there's data. So I think these questions are very, very live debates. And this has been grafted onto the existing debates on, what can be the object of an armed attack, in contravention of Article 2.4 of the UN Charter. The General Assembly Resolution on Aggression is listed as, a number of items which, some commentators would suggest are sort of, among the lists that could be objects. It may well be that there could be, this is where the law could develop in a sense, in terms of what parts of cyber infrastructure, what parts of cyber, eventually could be deemed to be those types of things that attack, that constitute an armed attack or an act of war, as was said.
Very much. I have here a continuing question which relates, something that was said, that also relates to the Estonia incidents, which you will probably recall, which happened in 2007, where the government of Estonia and also the Estonian banking system, public service system was attacked by an ambulance attack. Numerous countries from all over the world, this like DDoS attack at a large scale, had immense economic effects in Estonia, although no deaths or serious injury. That threshold was not crossed, so to say. The question was, who can we attribute this attack to? And at the end of the day, it could not be attributed to Russia. That was the question of a political issue, had to do with a statute, remembering the war, and the Estonian government had decided to remove that statute, and guess what? There was unpopular in Russia, and then the attack started. But it was technically not possible to attribute these attacks, these attacks, to the Russian government. And then the question that I have here in front of me comes in. Well, if we cannot attribute it to a state, but to an individual, whose jurisdiction then would be applicable. This is a rather difficult question, but I'm looking forward to both our colleagues.
Yo creo que eso depende de la legislación del país. Que sufre evocación cibernética. Hemos visto en los últimos años el Departamento de Justicia nuestra encausaron, acusaron miembros de una unidad de China por entrar sin autorización a hacer hacking de computadores de los Estados Unidos. Según nuestra ley doméstica, hay jurisdicción. El problema es que no tenemos los cuerpos para ejercer físicamente la jurisdicción. Es una cuestión. Se tendría la complejidad del derecho penal en el ambiente internacional. Para tener jurisdicción tiene que tener un tratado de extradición con un país donde se encuentra el acusado. Y recién también el Departamento de Justicia acusó a algunos iranianos por lanzar un ataque, no sé esa palabra con cuidado, pero contra alguna cosa, una represa, ¿no? En los Estados Unidos. Entonces, la cuestión de jurisdicción va a depender de yo creo, los principios comunes del derecho internacional penal.
Just briefly, and again, I think this is where you really have to do your homework and figure out, what actually happened. What, as the electrodes pass through the ether, what was involved? Was it, what infrastructure? Was your infrastructure in more than one state involved? Both through source and through transit. And then I think that at those points, you have to start trying to assess, to diagnose, was there, did this happen passively in terms of state involvement, or was there acquiescence, and how do we characterize that? Because, there may be state responsibility at some point for the activities of groups, and indeed, I think one of the issues that we struggle in when it comes to law responsibility in the cyber realm is this notion of when people do things in a particular state, how does the state have, can that be attributed to the states under certain circumstances? We know from the ICJ and Court of Channel case that states have an obligation not to allow their territory to be used in other states. So how does that play out? Can we nonetheless to countermeasures. But I mean, this is the really tough stuff, and this is where trying to understand what cyber is about, can be complex. And I think especially for lawyers, unless you're really technically minded, you need to understand how it works.
Una palabra rápida sobre la cuestión de atribución. Esto es más un ejemplo de la presión que veo yo causado por el ambiente cibernético. Antiguamente, o recientemente, en el mundo físico, digamos, es un ataque yendo de un país a otro. En general, no es súper difícil identificar el autor del acto. Forensicamente se puede ver quién está atacando, preparando. Entonces, la cuestión de atribución en el ambiente de responsabilidad del Estado no es tan difícil. A veces hay operaciones clandestinas y hay cuestiones diferentes, es más fácil. En el ambiente cibernético es difícil. Y cuando uno está sufriendo el ataque en el momento, también no se puede quedar paralizado en defenderse porque no se sabe quién está realizando el ataque. Pero eso crea una tensión y riesgos de contraatacar o usar una contramedida que tiene daños o prejuicios en un país no responsable. Pero en el ambiente cibernético también yo creo que la posibilidad de limitar el efecto en respuesta bien dirigido al algo, vamos a decir, y no causando daños colaterales o efectos colaterales, entra en el análisis. Pero también, como vimos en el caso de Sony, fue la primera vez, yo creo, que pasó ciertamente para los Estados Unidos cuando el gobierno declaró claramente, atribuyó la acción al Corea del Norte. La capacidad de atribuir también está mejorando.
I have a final question which relates to the use of drones with operators in another country. As was pointed out earlier in one of the presentations. And the question addresses this situation: the drone flies over another country and is operating there, arms probably. The pilot, so to say, the operator of the drone is somewhere else in a home country. The question is it then legally possible, legally all right, to attack that drone operation center inside that home country by an outside group? This raises numerous questions, but I ask for a brief answer. I phrase the question like I do.
It's certainly not all good old college try. I think that one question would be is, are we talking about potentially an international armed conflict? I think if it's an international armed conflict, it's probably a little easier to answer in the sense that clearly the battle space in an international armed conflict can be two territories, to the states or the high contracting parties. I think with respect to non-international armed conflict, it can be a little more challenging because I think there's greater contention on whether or not, with respect to a non-international armed conflict, the battle space, if you have a, let's say a situation where state A has a NIAC in their territory and then state B comes in to assist state A, can the organized armed group from state A then go into state B to attack? I mean, there's different views on, as I say, on the scope of the battlefield. And you can make an argument that, you know, it could extend the lawful argument, but you could also make the argument that, you know, the NIAC is, you know, considering the ruling in Kadish, that, you know, the intensity that there is perhaps a geographical limitation to where, you know, where the actual, you know, armed conflict or the fighting, the violence is present.
Yo creo que la pregunta, aunque no sea del abogado cibernético, implica la cuestión que levanté sobre soberanía. Porque, claro, como mi colega dijo, si la drone está realizando una operación dentro de un conflicto armado, cambia la cuestión. Pero un dron entrando en el territorio de un país no es necesariamente un acto de guerra. Claro que basado en el principio de soberanía, reconocemos como ley fija internacional que ese país puede ejercer jurisdicción sobre ese dron. Y tal vez bajar el dron, tomar acción contra el dron mientras está dentro de su territorio. Pero lanzar un contraataque contra el centro de operaciones de ese dron, no necesariamente, porque no tiene derecho, si no fuera un ataque contra el uso alterno, no tiene derecho. Ahora, una contramedida tiene que hacer el análisis, que si es una intervención prohibida. Es la misma cuestión de soberanía. Entonces, la tecnología está levantando cuestiones sobre principios que, de cierta forma, hasta ahora hemos tomado como normal. Pues, no mucha discusión, pero están presionando los métodos de entendimiento de ese principio.
Thank you very much. Ladies and gentlemen, we are moving towards the end of this session. I will not even attempt to summarize everything that was said, but I do think that you are convinced with me that this has given us an enormous insight in the complexity of discussing the legal realm, so to say, related to the use of cyber, particularly, and slightly less complicated the area of drones. Let me highlight just two topics. I focus in the first place on the title of the interesting presentation by Gary Ford, where he said, I exclude the words carefully, I will talk about cyber confrontation. And that careful choice, of course, had to do with the precise words in the Charter of the UN about the use of force, Article 2 4 of the Charter. It has to do with self-defense against an armed attack. And the point is that he made that often a situation can occur that we can say it is a cyber attack, but it doesn't go over that threshold. And then you'll have the important questions of, and what to do next? And even if you can execute the attack, because that is one of the other complexities that we have discussed this morning. And the second item I want to highlight from the other presentation of Commander Thompson is the fact that we, on the one hand, can say with drones and automated systems and maybe autonomous systems with humans in the loop or humans on the loop or humans only in the programming phase of the automated weapon, we can still say that yes, there are big principles of international law apply with regard to distinction, with regard to military objectives, etc. But the question arises, how do we operate? How do we make that operation? Because you are aware that in a combat situation, it can be pretty difficult to discern at the right moment who is the civilian, for example, who is the military individual. And is this a use, a house in use only by civilians, or does it have a military use, and has it become a military object? And how do you see that then, as a drone operator, thousands of miles away, and we have that same clear view of that issue? And of course, the interesting issue, it was only touched upon briefly, but it refers to a discussion yesterday in the other panel about command responsibility. Who is responsible if something goes wrong? Is that the commander of the operation? Is that the manufacturer of the drone or the automatic system, etc.? So this raises all kinds of interesting questions also from having been a presenter, which they can put on the wall at home. And I will start, and I'll do that in front for the photo opportunity. I will start with Colonel Gary Paul.
Primero, si me permite, justamente para entregar el certificado de agradecimiento a nuestro moderador de la mesa de esta mañana, invitamos al general de la Policía Nacional de Perú, Julio Bueno Ligado, presidente de la Fiscalía Suprema Militar Policial. A continuación los invitamos a compartir un café, término del cual los invitamos nuevamente, ahora sí, para una segunda fotografía de recuerdo, para poder grabar terminado el café, vamos a tomarnos una fotografía de un espacio labor para las delegaciones extranjeras y una representación peruana. Muchas gracias.